well, let me back up before I talk about him and say, so that we're clear for the record, that this is a hearing on and that is the defense motion, to assert our privilege and right to a stand your ground hearing and ruling from the court on whether or not the civil suit can continue or whether or not that lawsuit ought to be dismissed because Mr. Williams was standing his ground at the time that this tragic event occurred. And so with that, it is in many ways a mini trial of sorts. I know that Your Honor has presided over many stand your ground hearings, and I've participated in many too, probably. And so I know that you know the law, and I'm not going to try to belabor that law, maybe talk about it more later than I do now. But it is simply, as you know, an extension of the right to self-defense, that the legislature codified the Castle Doctrine, which has always been a part of the common law, that says somebody breaking into your home, that you don't have to retreat, that you can defend yourself and kill them if necessary. And the Stand Your Ground law extended that to places beyond the house, including where you work, your automobile, and a place where you have a right to be, if you are not acting unlawfully, and if you were without the fault in bringing on the difficulty. And again, you got to go down and establish that you are entitled to a finding of self-defense. We will go through all of that with the court when I think probably more appropriate to deal with the law aspect of it. But first of all, obviously, you got to know the facts. The facts dictate what the law will lead you to in an ultimate decision, and so you got to get the facts right. And I know you've heard some things about this case. There's probably a lot that you haven't heard. I think you will learn a lot in these presentations from both sides, but I want to say to the court that it is the facts of what we have to deal with. The journalistic engine that has been created since this event occurred has got oxygen off two basic premises. One is that Weldon Boyd and Bradley Williams, since he was riding with him, chased Scott Spivey 9 miles, and then they shot him in the back. Both of those are wrong. They're incorrect, and they are illusions that I believe have been created by the delusion of the followers of Mr. Spivey. We'll show you those two premises are not fact. Now, first of all, we want the court to understand there are some differences between Mr. Boyd and Mr. Williams with regard to the facts to this case. Primarily in that Bradley was not driving the car at any time in terms of the word chase. Everybody likes that word. And at the same time, he made no decisions about the speeds that were driven, and he made no decision about turning onto Camp Swamp Road. And we believe that the evidence will be clear that he is entitled to a finding of immunity. But we believe that the evidence will show you, and I want to outline it for you briefly because hopefully it will help you as you try to listen and figure out what's important and what's not. But we think the evidence is going to show you at the end of the day. First of all, these two vehicles were 4 miles into this 9-mile stretch from Bell and Bell car dealership at Concealment Road before they encountered each other. They were 4 miles into it. We believe the evidence will show, and I'm pretty good at figuring out what the evidence is when I finally take a look at it. So there's no 9-mile chase. There's 4 miles where Mr. Boyd and Mr. Williams are riding down Highway 9, pulling the trailer, and there's no interaction at all with Mr. Spivey. Then there's 2 or 3 miles where there is interaction between those two vehicles. And then there's about 2 miles where there is the following or the pursuing, whatever you want to refer to it as, of Mr. Spivey's vehicle by Mr. Boyd. So there's no 9-mile chase of Scott Spivey. That's just wrong. And whatever your decision is, it ought to be based off the facts, not what some people want it to be, or what they want the facts to be, or that those rose-colored glasses they're looking through lead them to believe. The evidence will show that before Mr. Spivey ever encountered Boyd and Williams, that he was already road raging, or whatever you want to call he was doing. The evidence will show you that throughout this 9 miles himself, that he was pointing a gun at least 4 different people with a specific point. In addition to that, he was brandishing, waving, holding out the window, playing with, whatever you want to call it, that pistol. Loaded Glock 9mm pistol, and I say it was loaded because it was loaded when he jumped out with it on Camp Swamp Road. He's waving that gun at people. He is, before he ever runs into Boyd and Williams, he's driving his truck on Highway 17 and then on Highway 9 at speeds that are 35 or 40 miles an hour over the speed limit. On Highway 9, before he sees any of these speeds, he's driving that truck at speeds between 85 and 95 miles an hour. So I say that, Judge, because the evidence will show that the speeding and the bad driving was because that's what Mr. Spivey decided to do. The old solicitor Jim Dunn used to say, whatever he did on the road that day, he did for reasons that were satisfactory to himself and himself alone. He instigated it, he started it, he sustained it, he kept it up, and that was him. Everybody else had to react to Mr. Spivey that day. He was, for lack of a better term, as my mother would have said, he was a holy terror that day. Nobody caused it. We don't know why. I don't know. Maybe somebody in the course of the hearing can tell you why, but he was. The evidence will be from the witnesses that we call that he started early in this near Bell and Bell at Colonial Charters, pointing a pistol at a young lady named Blaze Ward, who was so upset by what happened that she monitored him herself throughout this, probably 8 miles for her. She followed him. You was hearing her testimony. She thought that she needed to keep up with him. She, as ways into that drive, called 911. That'll be one of the first pieces of evidence that you hear. And she says, he was the one causing the trouble. You're going to hear further testimony that just after that he pointed the gun at an elderly couple, forced them off the roadway, witnessed by one of the witnesses that we will call. She decided she needed to follow him and pursue him, that he was dangerous on the road that day. And that along there is where he took off and reached these speeds of 85 and 90 miles an hour there by Living Water Baptist Church and the river, Walkamaw River, in that area there. It was after that then that he came up and ran up behind a witness, Mr. Terry Wright, who would testify, and who Mr. Wright had been following Weldon Boyd and Bradley Williams along that roadway number 9. And again, I'm going to tell you that the best you can determine from all their testimonies, they're about 4 miles into this 9-mile stretch before these guys ever see, or Mr. Spivey ever sees these guys. And that at that point in time, that there is what the testimony will be, erratic, fast driving, pulling up behind, slamming on brakes, bouncing around, going left, trying to get around this track that might have been heavy in places, at least moderately so. And that eventually Mr. Spivey shot around the cars, got in front of, beside Mr. Boyd, and that's where the testimony would be from Bradley Williams, somewhere in that vicinity. He pointed the gun out the window at Bradley. Again, for reasons known only to himself. But nobody was bothering him. And as we know, before I forget it, he had earlier that day, maybe this is something to do with why he was doing what he did, he had been at Boardwalk Billy's Bar and Restaurant. And he had been drinking. And there's a bar tab that we will introduce in the evidence with some 12 drinks or more. Beer, fireball shots. Probably didn't drink at all, or he'd have been at a higher blood content than 13. But he had enough of it to be full of himself that day, frankly. And so he had left Boardwalk Billy's, went down Highway 17. We don't know where he might have went before that, but then he's down Highway 9. When he runs into them, then he points the gun at Bradley Williams. And for the next couple of miles, there is what our clients and Mr. Terry Wright, frankly, will tell the court, that there is a continuous messing with of Mr. Williams and Mr. Boyd by Mr. Spivey. I can only envision, as I hear some of it, a little bit, the Daytona 500 was yesterday, and back when I paid any attention to that, you know, Dale Earnhardt would try to block Ricky Gordon and they'd be back and forth. That's what I envisioned was happening on the roadway. Mr. Spivey would shoot around in front. They tried to move right, he'd move right. Move left, he'd move left. And this went on for a couple of miles. Finally, Bradley started taking pictures of his vehicle, and you'll see those pictures. They'll come out. There's some of them got the gun in them, some of them don't. Now, as they're doing that, there's what these speed guys will refer to as brake checking events, where an automobile is going along at some speed, be it 60, 70, 80, 50, and then all of a sudden it decelerates from 80 to 49 miles an hour. You may well see that as evidence in the case. And one of those led to Mr. Boyd being forced off the highway with the trailer he was pulling into the median. And obviously a very dangerous move. He could have lost control. He could have gone into the oncoming lanes. It was a grassy median, hit somebody else head on. But he saved it. He got it back on the roadway. But that went on for several miles. Back along, and Blaze Ward herself is following all this, going along the same way. She sees that, she calls 911. That's to hear you call. After that, Weldon Boyd calls 911. And of course, you will hear that. But what I would say to you is that he is explaining to the court, I mean the 911 people, what's going on, and the need to get somebody, an officer there, to get this guy off the roadway. And it's from that point on, as I think you probably know from listening to some of it, there's a couple of miles, and in this area there, the speed of Mr. Spivey, we know his speed because we got his data off the cell phone, for maybe a minute, a mile, I don't know, you can discern that, reaches well over 100 miles an hour. 100, 105, I think there was one at 113 miles an hour. Again, those were choices. He's driving in that manner. Now they're going to say, well, that Boyd and Williams chased him. Okay. And so they might have been, I don't know how fast they were driving. We were not able to get any cell phone information from their phones that would show any speed, because the phone simply didn't retain it, or what wasn't gained in time. But after that short stint of very fast driving, the last 2 miles of this ride are back at road speed, 60, 70, 50 miles per hour, before the turn onto Camp Swamp Road. Blaze Ward, I tell you this, I don't know how fast, we know how fast that electronic information is correct. I'm not sure what's correct and not correct with all this electronic information that we can derive from analysis, but apparently everybody believes in it. Whatever the speed was, Weldon here did stay within eyesight. And Blaze Ward, little blonde-headed Blaze Ward in her Altima, Nissan Altima, she stayed in eyesight in contact with him, because she said somebody needed to get that guy off the road. So she's there. And so at that point in time, there is the turn into, onto Camp Swamp Road. Mr. Spivey makes that turn. And then the testimony that you will hear is that, and that testimony from a guy named Frank McMurrow from Weldon, from Bradley, and that obviously is where the shooting took place. So, Mr. Spivey turns in, he abruptly stops. Weldon Boyd turns in that road behind him, sees that he stopped. He stops some 75 to 100 feet behind him. Didn't pull right up on him, saw him, stopped as quick as he could. And then Blaze Ward is behind them, and she makes the turn into Camp Swamp Road. Doesn't get very far, because the trailer that Weldon is pulling is almost back to number 9. But she was able to get in there. And so the testimony that you will hear from that point on is that Mr. McMurrow will say that he's approaching Camp Swamp Road. Strike that. He was approaching number 9 on Camp Swamp Road. And that he saw the black truck abruptly stop in the roadway. A man jump out with a pistol drawn. He is in the roadway. He says that he's got the gun. He can tell that the slide is back. He's approaching, and then he sees the white truck. And then he's all over the place, really, but you hopefully have all of his testimony and you can discern. But the salient facts don't change, and that is that Mr. Spivey jumped out with a gun, and that he was yelling, according to McMurrow, "Stop following me." And he had his gun, and there was a lot of questioning of McMurrow about, well, what did you say? Did you see him? Your statement says he raised the gun. Well, he tried to back up on that a little bit. I don't know why. But he said, well, he had the gun out, and he had it by his side, and he started a slight upward movement, and that went round and round. But it doesn't make any difference. The salient point of what he said is he jumped out with a gun. He had it in his hand. He was facing the white truck. He was yelling something at him, and that he had that gun in his hand, and he started to raise it. That's the basic aspect. He does not say that he saw Mr. Spivey point the gun at these two. But he says that he don't know who shot first because he is driving by. You got to remember, part of what he says he saw is he's looking in the rearview mirror trying to push his wife down so she don't get shot. But it's strikingly strange that one thing he does is as soon as he sees this guy out with a gun standing in the middle of the road, he says that he is immediately worried about his wife's safety, so he's pushing her down. So it don't take you long to figure out a man waving a gun, you better be scared. That's exactly what Mr. Spivey was doing. Again, for reasons satisfactory to himself, he stopped in the highway. Murrah says that Weldon Boyd and Bradley, of course, again, Bradley weren't driving, couldn't get around Mr. Spivey because he was coming down the road and they would have collided. So, the testimony you will hear from the witnesses, and then these two witnesses, Mr. Spivey and Mr. Williams, will tell you their version of what happened, which will be, as you've seen, that he was out, he had the gun, he did raise and point the gun, and he shot, and they immediately shot back. You will hear my client, Bradley, here say, "Back up, Weldon," when they got there. "Back up, Weldon, back up." And again, I'll say again, Bradley was driving. Bradley didn't follow, chase, pursue, or use any word you want to use to do this. He didn't turn into Camp Swamp Road. He was driven to the site where a man who had already pointed the gun at him and harassed him is out again with a gun. The shooting occurs. And that's exactly what went down. The other testimony will be, that I want to talk about, is shot in the back. Well, he weren't shot in the back, as you and I and everybody in this courtroom would understand that. He weren't shot, stand up, he weren't shot in the back. You got me? He weren't shot in the back, so that it went through the back, out the front, there you go. No, that's not what happened. What happened is, he is shot under what is called the ancillary region of the body, or the armpit, which is right here. Now, it is maybe what you might technically say is the back, but no, it ain't the back in the real world. It's right here under this armpit, and it travels through the body, never leaves the body, and is found in this pectoral muscle on the left side. It is consistent with when he got out of that truck. There's a question about did he shoot outside the truck or not shoot out the truck. There was one shell casing found outside the truck as evidence that it was shot outside the truck. That was all that was found, but we will present evidence that multiple cars went through this crime scene before the police had a chance to get in there and do what they needed to do. But whether, and I don't think anybody knows for sure where Mr. Spivey was hit. But the pathologist and the autopsy report and the medical personnel will tell you that the shot is consistent with being shot while the arm is raised. It's obviously, we know that Mr. Spivey was out of the truck. He got back into the truck. We know he was actively involved in the shootout because there was a shell casing outside the truck. There were 10 more inside the truck. 9, 10, 11, I'm not sure, those numbers mix up. But clearly, he had, before he died, he emptied the magazine in that .40 caliber Glock he had. And he had within arm's reach 2 other loaded magazines with probably another 45 bullets in them before he died. And all of that can be debated in different ways, but those are the facts. Those are the facts. And based on that premise of chased him 9 miles just so he could run him down and kill him, you're wrong. It's not fair. This is a place where we come to find the truth, and we would want you to find it here. We want all the facts to be laid out, any and everything. Hide nothing, show it all. because it's clear that the evidence will bring you back to the idea that this is not anything but a clear, Judge, case of stand your ground immunity. It ain't close, I will tell you. Actions of the Horry County Police in connection with this are part of a separate investigation, and I know that they would like to make it part of this case, but frankly, all the facts that matter happen before a policeman arrives at the scene. Got nothing to do with what happened here. Now, I appreciate your patience in listening to me, but I think it's important that not only you, but that everybody in this courtroom understand what the fact, and I hope they stay and see the evidence that is put on the witness stand that will support the argument that I have made to you. You know that this is a case in which the burden is on Mr. Williams, but it's only a preponderance of the evidence. And I've actually toyed with how to have a motion to dismiss, and probably will at one day if Your Honor were not to rule in our favor in this case. Because, again, all the conduct complained of as bad was not Bradley Williams. He, at the end of the day, Judge, Bradley here, who is 36 years old, married, 2 children, fine young man, from all I can see in the journal about him, works every day at a construction job, had come to Horry County to help Weldon Boyd, who was a friend of his, move some furniture and do whatever might come up over the weekend. He didn't know Mr. Spivey. He didn't know any of Mr. Spivey's family. He didn't know a thing in the world about him. He's minding his own business and finds himself driven to a place where a man has got a pistol out, pointing and shooting at him. He had no choice. You know that self-defense is built on the law of self-preservation, which is the strongest instinct a human has. It's genetic. You're predisposed that way. There's a desire to protect yourself. That's what Bradley Williams did. This law that you're dealing with is exactly what the legislature, I believe, intended to protect the Bradley Williams of the world in cases like this. And accordingly, we filed a motion to have it dismissed. Thank you.
Yes, sir.
Yes, sir, Your Honor, I want to supplement that. I'm not going to go into those same facts that Mr. Morgan spoke about, Ms. Martin spoke about, but I'm here representing Weldon Boyd. I'm proud to represent Weldon Boyd. I've represented Weldon Boyd for probably going on 10 years now. And he has been a bit of a lightning rod over the years with his differences of opinion with some elected officials in Horry County. And none of that's relevant to this case, but it is, and I'll explain shortly. Immediately after this case started, here comes the conspiracy theories. Here come the conspiracy theories, and it wasn't just one or two, it was dozens. And this plaintiff, and this plaintiff's family, and those that line with them, have chased every one of them. And they've shown up in pleadings. Okay? They've shown up as allegations in pleadings that there's no basis for. And so we were going to ask Your Honor to confine your review, as we know you will, to the evidence presented from the witnesses that were there. Now about that, we have a couple witnesses, as you know, we've had a difficult time getting to participate in this case. A really hard time. Finally, and thankfully, they came to depositions, and you know what they did? They corroborated their statements made to the police within minutes after this incident. Now, these witnesses have been doxxed. These witnesses have been, I don't know what the word you want to use is, but they've been tampered with. Whether it's intentional or not, they've been tampered with by this. Okay? They've been tampered with by trying this case in the press. And so these witnesses are proud. Okay? And you'll hear, particularly in Mr. McMurray's you'll hear him change his story a little bit from what he told law enforcement within minutes after what he saw. And within minutes after what he saw on a body cam recorded video. So you'll be able to see exactly what he told law enforcement within minutes before he had the opportunity to speak with anybody else. He didn't know my client, he didn't know Mr. Williams, he didn't know Mr. Spivey, he didn't know any law enforcement. But he stayed thankfully on the scene and he told the law enforcement officers what he saw in this recording. And I submit to you that is the most credible and reliable information that you'll have. Same thing with Blaze Ward. Blaze Ward was doing what my client was doing. They saw a terror and a menace on the highway who reigned terror for at least 14 miles. Okay? Over 6 of which before he came into contact with my client. My starting place is a little bit different than Mr. Martin's based on this evidence that we just got last week. Okay? It shows that it's a longer reign of terror than we first thought in this case. She thought she needed to follow and get on the phone with 911 because this man is dangerous. He's going to hurt somebody. That's what my client did. Now, I will suggest to you that this case is going to be primarily decided by you on stand your ground principles based on the statutory elements as the court has adopted that statute. But there's another part of this, because there's going to be a suggestion to you, well, after this menacing terrorist on the highway pointed this gun at Mr. Williams, maybe they should have left him alone. Okay? Maybe they should have just let him go on his way. And maybe they should have. Okay? But that's not what the law says. Okay? The law in South Carolina, as declared by our South Carolina Supreme Court, is my client had to do to follow this man and get law enforcement to him. Now, whether everybody would have done it, that's for them to decide. But my client said, this is a menacing terrorist. He's going to hurt somebody. Law enforcement needs to find him. Where is law enforcement? We're talking about 14 miles of a reign of terror. No law enforcement. You'll hear me now when one call. His sole purpose was to get law enforcement to this man, to make sure law enforcement could find this man. Well, that's what Blaze Ward was doing. And so the suggestion somehow that my client is some person who's a fight looking for a location applies. I mean, that allegation is nonsensical when you compare it to this little 20-something-year-old blonde-headed petite girl who's doing the same thing. Okay? It's one of these theories that just doesn't make any sense. I submit to you that law enforcement needs citizens to step up and tell them what they're seeing and where they're seeing it, and to call them someone help from law enforcement. The Supreme Court says that's what we have a duty to do. And so I welcome you to look at this evidence. I welcome you to hear from the witnesses. To also look at what the witnesses said that night before they were influenced by outside forces. And you'll make a decision, I know you will, applying the law in South Carolina. So I will end with that because Mr. Martin did a pretty good job of laying the facts out.
Thank you, Your Honor. I don't remember the date we were in the other courtroom down there and they were asking Your Honor to preliminarily rule, call it a motion in limine, rule that these statements that were collected by the police that they say don't have anything to do with this case is enough for you to rule on. And I argue not that you weren't competent to decide what you can consider and what you cannot consider in terms of whether they satisfy some hearsay exception, but that those words on those papers were not accurate. And I flipped to later in the statement, for instance, and I would show, Your Honor, that the words were not accurate. Now, Mr. Martin, I'm going to try to respond to all that, but I want to start there. He said, hopefully you'll hear the testimony. You know why he said that? Because they're not going to play it. They're not going to play Frank McMurrow's deposition testimony. They're not going to play Blaze Ward's deposition testimony that she gave on Friday, because what they said was, that's not accurate. And that what actually happened is Blaze Ward witnessed these two men chase him relentlessly, Scott Spivey relentlessly, like white on rice, from Colonial Charters all the way to Camp Swamp Road at a high rate of speed, so fast, Your Honor, that she wouldn't look down, that she wouldn't call 911. And he didn't even call 911 for 4 miles. He's a menace, he's a terror, 14 miles, and he chases him at 100 miles an hour before he even calls 911 to get up to 113 miles an hour. There was a menace and a terror, and it was the two people who were heard in the 911 call saying, "We've got our guns out too." The very beginning of the 911 call. We can try this case on the words because the words matter, but it's their words. And the chase, and you've heard Mr. Martin do this in hearings, and you heard him do it again today. They want to get away from this chase word. Chase. For some unknown reason, Mr. Boyd was secretly recording his calls. I say secret because the people he's recording don't know he's recording. And so when this initially happens, there are search warrants to get the phones. Well, Mr. Moss works out a deal that the Horry County PD doesn't get the phones. And they eventually work out a consent. They turn the phones over, and certain things are downloaded. Well, when they get downloaded by SLED, we have about 90 phone calls that Weldon Boyd made. One of those calls was September the 11th. The shooting is the night of September the 9th. September the 11th, 7:14 p.m. and 10 seconds. He calls his mother. They're talking about whether or not there's some connection. You're going to hear some testimony between Scott Spivey and Mr. Boyd's ex-fiancee. And his mother says, and we've got this in our brief and it's in the record, "Did the guy think you were following him, Mr. Boyd?" "Oh, he knew I was following him." Me and you talking? His mama, confidentially. The biggest supporter he has in the world, his trusted confidant, in private, in their secret moment. He knew he had fucked up at that point because all the other cars slammed on brakes and was trying to get away from him. And I was like, he just ran me off the road and aimed a gun at Bradley's head. Fuck this guy. And I chased him. Oh, I was on his ass, and his truck couldn't outrun my truck. Chase is not our word, Judge. It's not the podcaster's words. It's not the media's word. It is Weldon Boyd's word. And he relentlessly, and this is what the testimony is going to show, he relentlessly chased Scott Spivey and murdered him. Now, I agree with Mr. Martin that there is a privilege and a right to stand your ground. But you cannot stand your ground when you're chasing somebody else's. You can't do it. Because you're not acting unlawfully. You're not acting without aggression. And you do not have a right to be where you are. Because this is approximate cause analysis, and I know you know that. But the place where you have a right to be is not just some geographical place in the world. Hey, this is a public street. No, sir. It matters how you got there, because how you got there determines whether you are without fault bringing on this difficulty. And when you chase someone, you are solely at fault. Blaze Ward follows. Yeah, she followed from a safe distance. I mean, everybody's been in traffic where you cut somebody off, you've done something unintentionally, some crazy fool behind you is throwing his hands up and he's cussing at you and he's flipping you off. And for a few seconds, it's terrifying. And you don't make eye contact and you keep driving. Now extended over 9 miles. The witnesses have Weldon Boyd interacting with Scott Spivey at Colonial Charters. It's about 9 miles. They then, according to the witnesses, Gail Graham, Wrights, there's an instance where Weldon drives off the road, immediately drives back on the road. You can hear lots of testimony about how fast his truck is, how powerful his truck is, and then they begin this relentless chase at speeds that go, in this first stretch, up in the area of 100 miles an hour. There's nobody that testifies that Scott Spivey flies by us going 100 miles an hour. That's not the testimony. The testimony is this is back towards Bell and Bell. It's about 10 miles from Bell and Bell. It doesn't happen at Bell and Bell. That's a 57 crossroad, but it's just right beyond that. And then you'll see when we get to the GPS information, you'll see. I'm not the smartest lawyer in the world, Judge. I know that. In fact, half the time I think I don't know what I'm doing. But I have never seen a road rage case where the road rager was being chased by an innocent person. When you see those videos on the internet of road rage, some fool's coming up and he's beating your side mirror off, he's pounding on your door. He's trying to get you, not get away from you. Your father had a case, State versus Hendricks, 1978. The Supreme Court ruled that a withdrawal from aggression, let's assume that there's some aggression by Scott Spivey. And you'll hear Mr. Boyd tell the 911 dispatcher and every other person who would listen to him that he was trying to run from me. A withdrawal after aggression, which was communicated either by his actions or his words, would restore his right to defend himself. And in that case, this is the case with the tomato patch that had the words, "You and I are going to fight." And I really thought that your father's client had some fault in bringing on the difficulty, because when he goes down that road, I forget the guy's name, where he lives, well, it's obviously it's Hendricks, he passes him in the road. And Hendricks, who's drunk, gets out and he throws his arms up in the road. And I said, well, I mean, clearly he's instigating him, right? I mean, clearly there's nobody that lives down there, from my reading of the case anyway, you probably know. Nobody else lives down there, so this guy has come there, Hendricks has come there, obviously to instigate this. And then he goes back to his own property. He retreats. Yes, sir. That's right. And as a matter of law, your father was right. As a matter of law, he had a right, because he retreated, because he left. Even though he might have done something wrong, this is not a case about whether or not Scott Spivey did something wrong. That's an issue for another day with the jury and some comparative issue. They have the burden of establishing that they have zero, without fault, no fault. Not the dispatcher not tell me to stop chasing, even though I'd chased somebody before and I knew I couldn't chase them, which you'll hear that testimony from Mr. Boyd. Not that there was somebody else. None of that. And I've read some of the orders that you've ruled on this issue, and I understand that there is a right to act on appearances from time to time. But that ain't this case, Judge. Because if you look at, and I've cited State versus Starnes, 2000 Supreme Court opinion where the Supreme Court ruled, that case there were two guys. And the testimony from the defendant was, he pointed the gun at me and it clicked and I shot. No appearance there. Not, I saw him digging in his pocket. Not, I might have thought I saw something. That's this case. This case is, he shot first. He shot fucking first. And that first lie is told by the innocent passenger who had his gun out too. You can't get away from the lie. And that's what you're going to hear with Frank McMurray. What he's going to stand up in that video that I'm going to play, and he's going to show Mr. Martin, when I say upward, he just turned, just like that. He just turned. He didn't point the gun. He didn't threaten them with the gun. He didn't raise the gun. He didn't do anything. And he said, before Weldon Boyd emptied his clip through the magazine, through the windshield, I don't even think he would have had time to load his gun and raise it up. That's the testimony, Your Honor. It seems to me that if there's a chase, the case is over. This motion's over. And that because you can't be without fault if you chase somebody. And that's why they don't want to talk about that word. I also don't understand, and I assume they're going to bring some of the police officers in here. One of the first things you're going to see is they're going to start with a bar tab. And Mr. Martin talked about how much alcohol that Scott Spivey had consumed that day. One of the things that we did is we went and we deposed the manager of Boardwalk Buildings. Because, I mean, this is Myrtle Beach, right? All these people, tourism is a big deal, and they know how to serve responsibly. They're trained. They monitor. They monitor the number of drinks. And what you're going to see when they get that, bring that receipt in here, is that Scott Spivey was at that bar for 5 hours, and he was eating food. And that Horry County Police Department, after being called by Weldon Boyd, after the number 2 man at Horry County PD sending the right people to make sure he was taken care of in the shadows, sent somebody to Boardwalk Billy's to get the video. And they went down there, and they got about an hour and a half of the video when he was there for 5 hours. They didn't get it all. Why wouldn't they get it all? Why does he need Horry County PD to help him if he didn't do anything wrong? The video that they got, you'll see when it starts, he's got 1 beer that he sits there for most of the time. And then he orders Fireball shots, and he drinks those with 3 other men. And then he orders 1 beer right before he leaves, and he eats a cheeseburger. And I know that because you've said it, that criminal is your area more so than civil, but generally speaking, in a civil case, alcohol, consumption of alcohol, blood alcohol, would not be admissible without evidence of impairment. You know, they said, oh, it's not illegal to drink and drive. It's illegal to drink when your materials are, when your faculties are materially and appreciably impaired. What would that be? Well, you couldn't drive at 100 miles an hour through heavy traffic without running off the road, without hitting anybody for 14 miles. It's the opposite. It's the opposite. Their case is smoke and mirrors. They don't want all the evidence. They don't want to talk about the actual evidence, and that's what we're going to try to get you to focus on today. Shot in the back. In his deposition, Mr. Boyd demonstrates to me what Scott Spivey did. He gets out of his truck and he advances. Now, in the police station the night of, he doesn't say that. He has him in the door, just like Frank McMurrow does. Frank McMurrow says he moves, Weldon Boyd empties the clip. You'll hear it in the 911 call. This guy just emptied his clip through the windshield into this guy. Bullet goes in here, it's here. This ain't rocket science either. He gets into his truck. Now they describe, both of them, the innocent passenger who had his gun out too, who lied first, and the chaser. They describe this shootout where Scott Spivey advanced. There are no shell casings anywhere in that vicinity. There are no bullet holes in his front. But you're going to hear over and over and over again in these recordings, Weldon Boyd will say that I saw his shirt crumple, I think that's the word he uses, outside the truck, I hit him. In one call, he's going to say he slumped over. Slumped over. Slumped over. And he took pictures of him slumped over in the truck. The same way. It's impossible for the physical evidence to match their description, but it does match what Frank McMurrow says. And what Frank McMurrow tells this court is that on this day, for whatever reason, Weldon Boyd was having a bad day. No question about it. There was a text with his mama. She's never seen him this dark. He's lied about his medical history in relation to this. He just posted on Facebook listing the vehicle and the ring he'd just taken back, served his soon-to-be baby's mama with papers to get this back because they called off this engagement, and he pulls onto the road and he's mad. Then there's a relentless chase and a murder. Judge, this is not a standing ground case. This is a chase. This is a chase by, and you're going to hear, I don't know how many lies. I tried to count the lies. You're going to hear over and over and over again about their lies. Both of them. They lied in their deposition. You hear them narrating and coaching and orchestrating a story, tailoring their story to words that are close to what you've heard here today over time. But you know, there's two things that I think are the most powerful. You're going to hear the audio recording of the shooting. And we have an expert, the expert really, in gunshot acoustics, Dr. Meyer. And there's a motion about this, and we're going to have to take this up at some point in time. But I think you're competent to hear that testimony, decide on that. They think you're not. But what Dr. Maher did is he analyzes the audio from the secret recording of Weldon Boyd. And because he shot first, right? He shot first. So is there a shot before that? There's not a shot. There is no shot. And not only is there no shot, there's none of the other indications that there's a shot, like thug. You'll hear in the testimony, in the recording, Bradley later says that. You don't hear Weldon Boyd drop his phone. You know why? He told 4 people, I had the phone on 911 to record it all. I intentionally left the phone on to record this. Now, he doesn't say these words, but the point is, when I killed him. He manifested this. He knew what he was doing, and he did it. He was back in his element, he was loving it, and he had a fucking blast. Those are all his words. But in the immediate aftermath of the shooting, Bradley Williams turns to him and says, God damn it, Weldon, why couldn't you fucking leave him alone? That's before the lawyer strategy, that's before the joint defense agreement, that's before anything. And that's the reason Weldon Boyd's at fault. Now, I'm no criminal lawyer. I'm not ever going to be a criminal lawyer. A hand to one, you know, all this mutual combat where the mutual combatants, they can all be charged. That's something for another day. But there is no question that Bradley Williams lied. There is no question that Bradley Williams says, I was in full agreement in his deposition to go along with this. 2 other things, Your Honor. I made a motion related to Weldon Boyd telling Bradley to delete our Facebook messages. Not only delete our Facebook messages, but if the police ask you how we communicated, just tell them we communicated these other ways. Don't tell them about this, and make sure you go back and delete this. And he did. And we got an order from Your Honor week before last, asking SLED to look, to search for those deleted messages. They did. They're not there. They're deleted. They deleted them. The poor innocent passenger, complete agreement. You'll hear him. He voices a question. Just delete this? Yep. Okay, got it. Thanks. Yep. The final thing I'm going to leave you with, Judge, is you're going to hear the testimony that Weldon Boyd had a dash camera. And we know he had a dash camera because he told his baby's mama he had a video. But we really know it because he told his mama. And his mama says, but the video shows, and he says, I don't know. I haven't seen the video. Does it start too late? Does it cut off? I haven't seen the video. And Frank McMurray is going to testify that when Ken Moss called him, he told him that there was a video that cut off as Frank McMurray is pulling up, just before the shooting. There's no video, Judge. If you stand in your ground and you have the right to be where you are and you're a good Samaritan and you're a hero and they're going to march you down to the State House and they're going to give you a medal and a proclamation of bravery, the first thing you do when you get out of your truck is you say, hey, I got it all on video right here. You're not going to hear any testimony he said that. The only person he mentions the video to is his mama and his baby's mama.